Good afternoon. We gladly welcome everyone in attendance today, particularly those who work in our Pennsylvania dependency and family courts. We recognize how very difficult this work is and acknowledge that everyone involved has the best intentions and strives to do their very best. This has been reflected by the gracious manner in which our outreach informing the counties has been received. I am Jeff Steiner, the Executive Director of the Dad's Resource Center, which was founded by Dr. Joel N. Myers to provide education, resources, and advocacy for fathers striving but unable to be fully involved in the lives of their children. Research overwhelmingly shows that children have the best chance of becoming healthy and productive adults when both parents are actively involved in their upbringing. When that opportunity is unnecessarily restricted, children suffer. We are honored to help organize this important briefing because it addresses a well-documented and consistent concern that we have heard from the many of the 200-plus fathers from across Pennsylvania who have reached out to us for help, as well as mothers and even grandparents who have contacted us desperate to be in the lives of their children and grandchildren. Their experiences highlight how critical it is to ensure the best possible outcomes for children served by our family and dependency courts through fairness, consistency, and accountability in all areas, including the use of guardian ad litems. We have seen guardian ad litems who exemplify professionalism, neutrality, and a commitment to the best interests of their children. We have observed situations where that standard has not been met and situations where already difficult circumstances have been made worse by guardian ad litems. These realities underline the importance of today's discussion. Because of this, the Dad's Resource Center partnered with Rael LaPenta from PA Protect Kids and child advocate Holly Gogger to host this briefing. Our intent is not to criticize, but to initiate a constructive discussion about how oversight procedures and management of guardian ad litems might be improved across Pennsylvania counties. Today's briefing will feature Controller Mark Pinsley talking about his special report on guardian ad litems in Lehigh County, an informational video about guardian ad litems in Pennsylvania, testimonial videos relaying citizens' experiences with guardians, and Robert Garza, the Director of Americans for Judicial Accountability. Our ask is simple, that each county review this information, reflect on how guardian ad litems are currently managed, and assess what changes could best ensure that the vulnerable children in these systems truly have their best interests represented. We are making the information provided today available through a link to the Dad's Resource Center. We'll be forwarding a recording of this briefing to each county for those unable to attend, and stand ready as a resource for any court or county that wishes to engage further on these issues. On behalf of the Dad's Resource Center, Rael and Holly, thank you for joining us today. Please feel free to post any questions in the chat. Now, I would like to turn this over to Lehigh County Controller Mark Pinsley.
Hi, thank you, everyone. So my name is Mark Pinsley. I'm the Controller of Lehigh County. Most people don't know what a controller does. So what I like to start with is we're about fraud, waste, and abuse, meaning that we follow, we look for fraud, waste, and abuse and methods of correcting it. So maybe a little bit different than what Jeff said. I am here to criticize the GAL a bit and offer, recommendations on how to make changes. On the fraud side, what I like to make sure is clear is that fraud is illegal. So when we find fraud, the goal there is actually to report it potentially to the FBI or the DA or something like that. That's not typically what we find very often, and we did not find any fraud, on the GAL side. Waste is like a broad bucket, so it comes in many forms. It can be, it could just be procedural where we can save money. It really can be anything. And like, that's probably the bucket that we use the most. And then of course there's abuse, and abuse is really, where somebody is using their position in a way that doesn't, is inconsistent with their mission. That's what I would say. We ended up looking at guardian litems as a controller because we had several complaints from parents, and we had those complaints really from two groups. So one was those that were in family court, and then those that were in foster care, who had their kids being taken. Then I'll go into that in a little bit more in a second. One alternative, just for all of you to know, beyond looking at your local controller, so almost every county, I think in our 67 counties here in Pennsylvania, has a controller in some form or fashion. There are 38 that are very specifically controllers. Um, but you can also go to your auditor general or some variation that other states have as an auditor general. They actually have more direct access to court information that we as county controllers don't always have access to. So as you're doing your investigations, please make sure to look at both the county side as well as the state auditor general side. In the state of Pennsylvania, the courts get money from both areas. So they get money from the state, which gives the state the ability to look at it, and they get money from the county, which gives the county the ability to look at it. So we see GALs really in three perspectives. One is foster care. So that's really typically dependency. There's a reason that the child was taken away from their parents. It could be a variety of reasons. Whether it's fair or unfair, it wasn't for us to determine. But once somebody goes into foster care, we, the county, are paying money for that, which gives the controller visibility into it. So we're paying for the GAL themselves, we're paying for the foster care in many cases, and we may be paying for an outside lawyer as well. And that outside lawyer might be for both parents individually or together. And then, of course, we're typically paying children and youth, or your variation of children and youth. The second area is custody cases, which are really around family court decisions. We have a little bit less visibility into that because we're not paying the bills. When I did my report, we ended up having discussions with different families that had custody cases. So a lot of that information came from those families, not necessarily direct information that I had from a county level. And the last portion is aging, so where people have parents that have aged out or have aged and maybe they can't take care of them and there's a guardian ad litem assigned. Or in fact, if the aged person doesn't have access to any family, which is often the case, a guardian ad litem gets assigned. We didn't really deal with that in my report, but that is another area that we could look. As many of you probably already know, a GAL is meant to be a lawyer, at least here in Pennsylvania. Every state is different. That person is appointed and is supposed to have the legal best interest of the child at mind. And one of the things, obviously, that we found that most of you know is that term is ill-defined. And that makes it very difficult, both for the guardian ad litem, but also for us as controllers to say, are they in fact doing their job? So we believe that it needs to be clear that the GAL is not acting as a lawyer for the child. And we found that many parents were confused about that. They believe that the GAL was acting as a lawyer for the child, not just in the best interest of the child. And the difference is if you're acting as a lawyer, then you have to do what the child says. So if the child is of age, let's say 14 or so, and can communicate what they want, the lawyer has to do what that child is asking them to do. If it's a guardian ad litem, the guardian ad litem is supposed to be providing information to the court and to the parents and to children and youth in some cases as to what they recommend based on what they're seeing. So what we ended up seeing was that the guardian ad litem should be acting more like a detective than a lawyer. And unfortunately, we weren't seeing that detective work as well as we would have liked. So what we were hoping was that we would see things like they would investigate allegations and they would provide the facts, that they would conduct interviews, potentially with family members, friends, schools, etc., that they would perform visits, they would access areas of education, healthcare, things like that. We did find that some of them were doing that and that some of them weren't doing that. One of the reasons that we found as we reviewed the GALs, we noted that the compensation that we're paying anyway is around $100 an hour, which is low in our area. So, in our local area, a typical lawyer gets about $500 an hour, on the sort of medium end, probably $250 on the low end, and obviously $1,000 sort of on the high end. But if you are making $100 an hour when you were making 500, and you have to travel, let's say, an hour to go see that child, and then an hour back, and of course, whatever time you spend, well, now you're sacrificing those hours that could have been spent on something else. And we have seen some guardian ad litems that just don't go do that, right? The $100 an hour that we're paying is just simply not enough for them to go travel to the child and then come back. And so they're relying on other sources yeah, they're relying on other sources for the most part. We were also noting that the invoicing itself doesn't have any standard requirements. So when we get invoices as controller, we're looking for some standardization. For example, what we want to be able to see is that, what did the lawyer do? Did he or she talk to the child? What time did they spend on documentation? What time did they spend in courts? And in some cases, we would see that. So there were some guardian ad litems that really detailed out what they were doing, and you could see the amount of time that they spent with the child. And in other cases, we would basically get one line, which would be the child's name and then an amount. So, child one, $4,000. And somebody signed off on that. So I'm not saying that there's definitely no backup material, but we never had access to that. And the courts decided not to participate with our audit, which made it more difficult to verify. But from my perspective, so from the controller's perspective, when we saw invoices coming in and those invoices don't have the detail, that's a red flag for us. We want to make sure that there's detail and that we know how much time is being spent for each child. And then there was just ethical concerns. And the problem is there's a perception of bias, and that perception typically comes from the parents. So either one parent or the other feels like the guardian ad litem is choosing a parent, or in our cases, for the most part, the parents felt that the guardian ad litem was choosing children and youth over their experiences or their life. And of course, um, that perception in and of itself is a problem, right? Like our goal is not to have these kind of perceptions. Our goal, meaning the county's goal, is not to have these kind of perceptions, because when you have that perception, it undermines everything, quite honestly. Like we need the parents to believe that we are in fact working in the best interest of the child. And we need to be obviously working in the best interest in the child. And many people are feeling that it's sort of predetermined as to what's going to happen. And because of that perception exists, families tend to lose faith in the system. And that's honestly not good for anyone. If you go to my report, what you'll see is about 7 or 8 recommendations. The ones that I wanted to mention today, one is there needs to be some kind of independent oversight and accountability, quite honestly. This could be done statewide or it could be done regionally, but there needs to be a group that, parents can complain to and that it's taken seriously. So not just the courts where you're expecting that the judge is kind of protecting the GAL, but something that lives outside of the court system, so that you know that your voice is being heard and that something actually is being done. There's an investigation that ends up happening. The second thing is that we're seeing is there's not a lot of conflict resolution. The resolution is really based on the judge. And if you believe that the judge is taking the side of the GAL, then there's obviously there's no party that you feel is independent. So I think that it's really important that we also create some kind of conflict resolution. That doesn't mean independent oversight. That means something different, so that we can resolve issues very quickly. And some of that may just be if you see greater separation between the judge and the GAL, then you might feel like the judge, in fact, could be the resolution. Clearly, there needs to be additional transparency. So there needs to be transparency on how often the GAL is seeing the child, who else they spoke to, what other tasks that they performed, so that parents know what was going on, the two lawyers know what's going, if there's or more lawyers that know what's going on. And that information should be given ahead of time. In some cases, we saw that didn't happen. So the GAL should provide a report that both parents get to see, the child's lawyer, should the child have one, gets to see, and perhaps the judge gets to see before the court case or before the hearing. Why? Because that gives everyone the ability to then have questions prepared for the GAL so that they can ask more in-depth questions. We thought that was one of the biggest issues that we found, was that because of that unfairness, we need to make sure that documentation is there in advance and that could be questioned by the lawyers. We believe that there should be established mandatory documentation so that we know exactly what the GAL is going to provide, what the backup is that they need in order to provide that information to the judge, and then also to the lawyers. One of the biggest issues is the best interest of the child. The best interest of the child. That needs to be defined very clearly because what I believe is the best interest of the child might be very different than what a parent believes is the best interest of the child, might be very different from what the GAL believes is the best interest of the child. Without that definition, each one of us is going based on our own feelings. I don't necessarily think that that's good. Just because a parent says it's okay to watch TV and eat dinner at the same time, and I don't believe that's true, that doesn't mean that either one is correct. And that's a very simple example. But we need to have a very clear definition on what the best interest of the child is, not just for the GAL, but also for the judge, so that we know that we're working in your child's best interest. And then lastly, really the parent needs to have a clear understanding from day one as to what the GAL is responsible for and what their expectations are and how easy they are to contact. Without that clear understanding, what we were finding is that in the early stages, parents thought that the GAL was a lawyer acting on behalf of their child. And from that point on, everything kind of went south because as they started to realize what the GAL was, they started to feel like the GAL was taking a side. That in of itself is a massive problem. And so my goal in all of this was to provide information, to our county and to our state, and for them to take action, and then also for you guys to take a look at what the recommendations are and move them into your county. So that was my conclusion. There's a next right now. Please enjoy this short video on GALs in PA, and I will be around for questions later. Thank you.
To more fully inform our discussion about guardian ad litems in Pennsylvania, this video will provide an overview of state laws, highlight statewide initiatives to establish standards of practice, review 2 county-level program reports or court ruling addressing GAL immunity, and conclude with an example from another state. Pennsylvania law guiding the use of guardian ad litems in dependency cases was signed into law in 1972, which requires that a guardian ad litem must be appointed by the court to represent a child in dependency proceedings. The law requires that the GAL be an attorney, and it gives them a dual responsibility to represent the child's legal interests and to make recommendations regarding the child's best interests. The GAL must meet with the child before hearings, conduct an independent investigation of the case, and review all relevant records and reports. The GAL is expected to participate fully in hearings and court proceedings, present evidence, and ensure that the child's position and wishes are communicated to the court. At the same time, the GAL must advocate for what they believe to be in the child's best interests, even if that differs from the child's expressed preferences. The statute also requires the GAL to monitor the implementation of court orders and services, ensuring the child receives necessary care, protection, and support throughout the dependency process. It established the GAL as both the child's legal advocate and a safeguard for their overall well-being in the child welfare system. The current law relating to guardian ad litems for custody cases was enacted in 2010. It states that the court may appoint a guardian ad litem who can be either an attorney or a trained professional to represent the best interests of the child in a custody proceeding, who shall conduct such investigation necessary to ascertain the facts, interview potential witnesses, including the child if appropriate, examine and cross-examine witnesses, make recommendations to the court regarding the best interests of the child, advise the court of the child's wishes to the extent that they can be ascertained, participate in the custody proceedings to the degree necessary to adequately represent the best interests of the child, and submit a written report to the court and the parties in advance of the hearing containing his or her recommendations and the basis for them. In 2006, the Pennsylvania Supreme Court and the Office of Children and Families in the Courts, OCFC, launched the Children's Roundtable Initiative. The state roundtable identified legal representation as a major issue because GALs and Child's Counsel varied widely in training, practice, and effectiveness. The work group developed the pre-service DVD in 2011 as a training tool for new GALs and child attorneys. The initiative was about quality control and accountability. They used this training resource to implement the statutory requirements already in place, specifically for dependency court proceedings, not for custody cases. In 2011, the Pennsylvania State Roundtable's Legal Representation Work Group released a guide with its recommended standards of practice. They also held focus groups with attorneys from different counties, as well as youth and parents who had been represented in dependency court, to capture real-world perspectives. The purpose of the standards was to ensure high-quality legal practice by GALs, Child's Counsel, and parents' attorneys, to promote professional training, reasonable caseloads, fair compensation, and accountability, and to create consistency in representation across all counties in Pennsylvania. Core practice standards for GALs assigned to dependency cases were made for client contact, case preparation, dual advocacy, monitoring, and follow-up, ethical duties and caseload, and time standards. These are not laws, but guidelines to ensure that GALs meet their statutory obligations. In 2012, the Pennsylvania Supreme Court's Administrative Office conducted a review of the Guardian Ad Litem program in Lackawanna County Dependency Court. The review was prompted by concerns about the county's GAL practices, including allegations of inadequate representation, poor oversight, and conflicts of interest. The program had relied heavily on a single attorney who managed an unusually high caseload. This raised questions about whether children's statutory rights were being adequately protected. The Supreme Court's office sent a team to examine case files, interview stakeholders, and compare practices to state law and national standards. The key findings: failure to meet statutory duties. GALs often did not meet with children as required, did not conduct independent investigations, and rarely filed motions or participated meaningfully in hearings. Over-reliance on one GAL. The county's program was concentrated in the hands of one attorney, creating conflicts of interest and bottlenecks in representation. Lack of accountability. There was little to no monitoring by the courts or county administrators of whether GALs were fulfilling their statutory duties. Caseload concerns. The workload was far beyond what one attorney could realistically handle while meeting best practice standards. Children's voices were missing. The GAL program often failed to ensure children's wishes were communicated to the court, contrary to both statute and juvenile court rules. A Lackawanna County judge was charged with overseeing the implementation of reforms. It is unknown to what extent they were implemented. The GAL at the center of the review was later convicted of tax evasion and sentenced to prison several years after the report. The Guardian Ad Litem program in Lehigh County was established to protect the best interests of children in court proceedings, particularly in dependency cases involving abuse, neglect, or unsafe living environments. The role is intended to be both legally significant and ethically vital, ensuring that children are not lost in the adversarial legal process and that decisions made on their behalf are informed, independent, and child-centered. While the mission of the GAL program is clear, the implementation falls short. Despite consistent investment, the county lacks standardization, transparency, and accountability mechanisms necessary to ensure the program functions as intended. Families and professionals have raised concerns about inadequate engagement, limited child contact, and over-reliance on third-party reports. These issues reflect systemic inefficiencies and a potential failure to meet statutory obligations. This review found that GAL appointments and compensation practices in Lehigh County are decentralized and inconsistently documented. There is no external oversight body to evaluate GAL performance, nor is there a transparent process for families to raise concerns. Invoices frequently lack detail. Adding detail would make apparent whether or not GALs engage with children as contractually required. Stakeholders report a perception that GALs are closely aligned with Children and Youth Services, CYS, or the court, raising ethical concerns. To restore public trust and ensure the GAL program serves children effectively, Lehigh County should consider adopting a structured reform model based on practices from states such as Florida, Maine, and Colorado. These states have implemented oversight boards, multidisciplinary support systems, formal performance evaluations, and regular public reporting, all aimed at improving outcomes and transparency. Minor children, NWM, through their parents, filed a legal malpractice lawsuit against their former guardian ad litem and her employer, the Defender Association of Philadelphia. The trial court dismissed the claims on the basis of quasi-judicial immunity, deeming the gal immune from suit due to her statutory role in advising the court. The Superior Court reversed that decision, ruling that gals are not within the scope of quasi-judicial immunity. The Pennsylvania Supreme Court affirmed the Superior Court's reversal. Pennsylvania's High Court made clear that gals in dependency matters do not receive quasi-judicial immunity and can be held legally accountable for malpractice. Maine has one of the most comprehensive statewide gal frameworks in the U.S. and could serve as a model to develop better practices for gals in Pennsylvania. Prospective gals must meet specific qualifications, including certifications, background checks, and training requirements. Rules cover conduct expectations, procedures for screening, appointment, oversight, and removal from the roster. There are defined appointment orders and duties, enforceable standards of conduct, an oversight system with complaint procedures and discipline and ongoing education and reporting obligations. Thank you for your time and consideration for the concerns about guardian ad litems in Pennsylvania, and we hope this information has been helpful. Better procedures, practice, and transparency will bolster public trust and help to ensure the best possible outcomes for the vulnerable children served by our dependency and family courts.
As the architect of Texas Senate Bill 718, our next speaker, Robert Garza, established a new standard for parental equality in custody determinations. This groundbreaking legislation, combined with the three strikes law for custody interference, has created a foundation for reform that advocates nationwide are building upon. In July 2025, Robert was appointed Director of Americans for Judicial Accountability, where he leads efforts to bring transparency and accountability to family courts nationwide. Please welcome Robert Garza.
Hi, everyone. I'm Robert Garza. I went through family court for about 16 years. Figured out that there's a lot of legal loopholes, and now I'm writing bills to shut them down. The legal loopholes. Family court, I think, just needs quite a few tweaks, and it would probably run a lot better than it's doing. There is a huge problem with interference with child custody. There's problems with perjury. I was trying to think of the name. So perjury right now is a state jail felony in most states, but nobody's prosecuting for it in family court. They do prosecute it in criminal court, but not family court, and that's the big issue here. And so what you come up with is a bunch of people doing false allegations, and then in family court, they do a very low standard, which is preponderance of evidence, and that's where you get a lot of these issues. They can just do a protective order, restraining order based on an affidavit, and it's just more true than less true, and the judge has full discretion to do this. And when you do that, along with these temporary orders, it's a big mess, especially right now, since judges need more accountability on why they're writing the orders that they're writing. And so that's kind of the issues that you get into. I came out with Time Taken, Time Back, which is a remedy that passed here in Texas for false allegations. And then now that that's done, it's passed also in North Dakota, and it's going through a lot of different of the 50 states also. The next one I came out with is Three Strikes Law. That one has to do with interference with child custody. And when somebody spends tens of thousands of dollars and goes through family court, you get an order, you try to enforce it, and then, you know, when you call the police to come out and enforce that order, they say it's a civil matter and go back to family court. Well, it's actually not a civil matter. It's a criminal matter. And in doing so, they're not doing their duty in doing this also. So if you interfere with someone's child custody, it's pretty much a state jail felony in all your states the first time that they interfere. And that's an issue that the cops aren't enforcing it. So what I've done is I've written a bill that it amends that state jail felony to be 2 misdemeanors before it becomes a state jail felony. That way, this is the only tool that law enforcement will have to combat this. So when they go out and someone's interfering, they'll give a $500 fine. It's like a speeding ticket. And if there's a real reason for it and you're a protective parent, you can go to criminal court, not family court, and get the ticket dismissed. But if it's if it's not a real reason, then, criminal court's different. Family court's preponderance of evidence. Family court is clear and convincing. And so that higher standard holds them to a different standard. And so if they can't produce it, then the fine sticks. So that's one of the biggest issues that we're seeing in family court. But this will solve that issue. And there's only two ways to alienate a child, and that's to separate them for 30 days or longer. And with the time taken, time back, that pretty much stops false allegations, but not a real allegation, because in that law, when you return the child, you shall return the time. And in doing so, it disincentivizes making a false allegation. The 3 strikes, when you do have a court order and it's not enforced, that fixes that issue, because the third time that you interfere, then it's an arrest, and it should be. So those are about to go through a lot of the different states as soon as we start November, December. In my own case, I did have a problem with my GAL. I kind of thought what everybody thought, also that she was, an attorney and did all these things, and ended up spending $160,000 on the GAL. She billed like I've never seen. And the crazy part is that it was right before a hearing. She would come to me and be like, "Oh yeah, your ex is doing this, this, this." So it was almost like she saw through everything. And I didn't know this, but she was also going to my ex and doing the same thing right before the hearing, and then asked for the billing, because if you didn't pay the bill before the hearing, then she wasn't going to go. So you're like, okay, she's on our side, and kept playing these games. Well, after hearing hundreds and even thousands of other parents on this matter, apparently this is a routine thing that they do. The other thing is, the GALs are usually the judge's friends, and that's a big issue also. There needs to be some kind of lottery system where, if there's 20 GALs, each one should have about the same amount of cases, not all to, 90% of them go to one person. That's an issue too, especially here, where we're at. And then the other thing is they need to stay neutral. If they're in the child's best interest, they just need to look at the facts. And the sad part is, looking back on this, in my case, I spent about $700,000 just being in my children's life. Went through about 34 plus false allegations, and they were all ruled out. I have joint custody of my kids, but why should we have to spend $700,000 just to show that you're a fit parent? That's not okay for any state. I don't know of a lot of people that can actually go through that. I didn't. I mean, I racked up 26 credit cards. And in doing so, this is why I found all the legal loopholes. And there's other bills that we're doing to shut down a lot of these things and add more accountability. We even put 7 citizens on the SCJC, and that's who you report to when there's a problem with your judges. And that committee had a less than 1% success rate in finding that the judges did something wrong. So now we passed a law here in Texas, and now it's 7 citizens on that judiciary committee. So we're doing some great things. It needs to be in every state, a lot of these things, and I think you'll see a big difference. Let's see what else I was going to talk about here. I think that's about it. If anybody has any questions, you're more than welcome to ask at the end of the session. Here's a video of montage of people and their experiences.
Guardian ad litem was appointed in my case to investigate SA against my nonverbal autistic daughter. The guardian ad litem was unhappy with me when she asked if I can pay her $150 up front and then pay her per hour. And I told her I don't feel comfortable paying her to do a job that the previous investigators, which is CYS, should have done. She got upset with me, and she said that I don't work for free and you'll just have to go to court without my recommendations. When she went to court, it was clear that she did not do anything as far as advocating for my daughter. Instead, she just made a few phone calls and then ruled in the favor of the person who paid her, which is my daughter's mother. She didn't even know my daughter's name. It was clear that she didn't do anything for my daughter besides making a few phone calls. The judge actually also ruled against the recommendations of the guardian ad litem. I got a new judge, and the new judge is going back to that case and saying, oh, he needs a mental health evaluation for saying the guardian ad litem didn't do her job. Week later, the director of CYS was arrested for endangering hundreds of children. And this guardian ad litem worked directly with CYS. She represented them in a couple superior court cases.
With the guardian ad litem is there's no oversight. There's nobody to protect the children. And after the interviews, it's whatever the guardian says versus the parents. And that directly puts the children involved in the courts. No questions asked. Everything that they teach in the parenting courses that they require you to pay for is exactly what the guardian is involved with doing. All of that information that parents are not supposed to disclose, the guardian disclosed.
I actually petitioned the courts for a guardian ad litem for oversight. Unfortunately, in my experience, my guardian ad litem did not allow me to record anything. She didn't want anything to be transcribed or noted. I believe that guardian ad litem meetings and sessions should be on the record. They should be completely transparent. I essentially had a guardian ad litem that refused to meet with me. She would not respond to my emails. In my personal case, my guardian ad litem did not want to have the facts presented to her of a pattern of abuse. My guardian ad litem had so much power in my case during a custody trial where I was not presented the reports that she was supposed to be doing, nor having an understanding of what protocols were adhered to my case and those stipulations that she was supposed to evaluate. Having so much power to be able to allow my son to be transferred from Pennsylvania to Maui, Hawaii. My guardian ad litem acted in extreme biased manners where she did not view relevant evidence that should have been implemented into the custody ruling.
The GL refused to have conversations with myself or many of the medical and mental health professionals that were involved with my son. She instead chose a side and actually inserted herself as an expert in many areas which she was not. Due to the GL's behaviors throughout the case has now caused my son to enter into adulthood and have to navigate obtaining these supports on his own. It has caused a severe harm and strain on my son's relationship with his siblings that will take years to repair following the conclusion of the case, and has also caused extensive strain on my entire family and our relationships with each other due to the GL's outlandish behavior that far went outside the bounds of what she was appointed to do.
Hi, my name is Holly, a resource parent and a provider. I have worked on cases in my contracted role and supported families with the assistance of guardian ad litems. The plaintiff in the case asked for a particular guardian ad litem to be assigned to the case. And on my side, with the defendant who did not ask for the guardian ad litem's appointment, did not have a chance to argue the appointment of this guardian ad litem. The court decided to appoint that particular guardian ad litem. It almost seemed like there was an attempt to have a winner and loser in the case. We attempted to provide our perspective as to why the case was so high conflict and direct the guardian ad litem to the professionals who had the level of expertise that our child needed. There was no reach out to the individuals involved, and there was an observation of several occurrences where this guardian ad litem acted well outside of her scope of expertise and provided opinions based on experiences they had decades ago. As far as reports are concerned, there were reports provided well within the time frame in the beginning. Toward the end, the reports didn't come at all. They provided these reports to the courts, and the courts definitely took the recommendations to a high standard, and it did not come with any kind of investigative backing. They did not contact individuals to get to the bottom of what the child's needs were, but there were contacts made in threatening ways. In my provider role, I understand that many parents do not understand what the role of a guardian ad litem is. And for us, me and a family that knew what the role was, dealt with some unfortunate repercussions, which definitely caused some harm to the family dynamic, which we went to the family court to resolve to begin with.
My mom lived independently and wanted to stay connected to her family. But on January 19th of 2023, without her knowledge or mine, she was placed under a court-ordered guardianship. Then beginning on May 8th of 2023, she was isolated from me, her only child, completely. Phone calls were blocked, visits were denied, and even when she asked to see me, her requests were ignored. Instead of protecting her, the guardianship became a weapon used to sever her from me. My experience highlights a bigger problem with guardians and guardian ad litems in Pennsylvania. They often act with little accountability or oversight. They can cut off family ties, claiming it's in the best interest of the elder, even when that directly contradicts the elder's own wishes. I lost my mom on January 8th of this year, 2025. She died after almost 2 years of forced isolation. We need reform. We need to protect against guardianship being used as exploitation instead of care.
Guardian ad litem was appointed for my child, supposedly to protect his best interest. Instead, he became the very source of harm. The gal showed up at his school unannounced and told him that there would be court in a few days. My child had no idea about court at all, and this news sent him into crisis. My child said he felt overwhelmed and just wants the courts to go away. The therapist's letter concluded that the gal created significant barriers to therapy and caused regression in prior progress on treatment. Even after the treatment team expressed serious concerns, the gal never asked about my child's diagnosis, never spoke with me as his parent, and never filed a report. My son's behavior spiraled into weeks of unsafe actions until he was hospitalized again. This was not neutrality. This was not advocacy. This was a dereliction of duty. The gal failed to meet the most basic responsibility to understand the child, to follow the law, and to act in his best interest. No phone calls, no emails, no conversation, no report. When a gal does not do his job, children suffer. The harm is not theoretical, it's lived. It's real and it's devastating.
Rael Lopinta is an advocate, educator, and reform leader committed to protecting children from all forms of abuse. A behavioral and sensory consultant, she transformed her lived experience with parental alienation and false allegations into a powerful force for systematic change. Rael co-founded the Interference with Child Custody Coalition and is co-sponsoring today's event through PA Protect Kids. Please welcome our chat host, Rael Lopinta, to moderate our Q&A.
Hi, thank you. So we have a question here from Mark from Spotlight, PA. And he was talking about his report that came out and how many people have reached out to him that they have suffered for the same kind of issue. And he talked about successfully challenging the fiduciaries and getting them to disgorge the money. And his suggestion was to say court challenges are the way to go. So I'm not sure if anybody on the panel will be able to answer this, but I guess the question is that a route that parents can go? Can they just challenge the court when a gal comes up, and how would they know that?
Yeah, I mean, you can always challenge the court. The problem is like it could take years just to go through that process. So I'm not sure that it's a realistic process, to start with. Perhaps lodging a complaint initially, and as I said, like I think we need an outside party, so a place that you can go, because right now you're still dealing with the court system, and I don't want to say that they're going to protect each other, but like, it seems to me that the courts overseeing themselves is a tough position to be in.
Thank you. And I know too, as a litigant in cases, you can't always just talk to the court. there has to be a certain procedure, and sometimes that isn't applicable in some cases as well. Nicole asked a question, and thank you for your service. You've been 20 years providing this for GAL services and custody evaluator. And her question was, are mental health professionals allowed to be GALs? And I can field that one because I know here in Pennsylvania, the rules did just change. So in custody, you now can have a mental health provider, but in dependency, you cannot. It still has to be an attorney. So I think that that's where the confusion is. There's two different rules. But also, she asked if there is standards for GALs in Pennsylvania.
Yeah, I can take that one. So you have two sides. You have the dependency side and you have the family court and custody side. On the dependency side, there are some standards in place. Our informational video laid out two different initiatives by the state on the dependency side to start to have some standards in terms of qualifications, ongoing training, supervision, and accountability, fiduciary accountability. But on the family court side, there really are no standards at all. Now, this also varies from county to county. We have 67 counties, and every county does things a little bit differently. So any county that doesn't do anything of their own volition on this matter, there are no standards. There are counties out there that do have some standards that they've implemented in their particular ways. I think one of the ideal situations, though, is that there's a good degree of standardization between all 67 counties, both on the dependency side and on the family court side, so that they're doing a lot of the same things, so that you can track these things universally across the state and be able to collect the data and observe and see how things are going from that perspective. So what we're doing today, we're asking each of the counties to look at this information, look at how they're doing things, and say, can we do better? And there probably are some counties that are doing a pretty good job with it. But ultimately, I think it serves everyone in terms of that transparency point, that everyone has faith in it, and also in terms of ensuring that you have the best possible outcomes for the children who are being served. If we really got a larger, consistent view of things and the way that we're doing things, to be able to assess it from that perspective. Thank you, Rayo.
And I want to point out in Pennsylvania, it was there was a resolution to have a study, and they did create standards, but it's not required. So it's sort of just a best practices guide. So no one is required in Pennsylvania to follow those other than the few bullets that are in the laws. And then Stephen asked a few questions, including what reforms do you think would happen? And I think, Robert, you could speak to what are some things that you see in other states that are effective with GALs, or some changes that you're seeing that might help us here in Pennsylvania?
Yeah, I think Pennsylvania should establish an independent statewide oversight board for GAL accountability, require GALs to document contract investigations, all the contact that they have, investigations and recommendations. They should create public transparency into GAL qualifications and training. They need a lot more of that. Ensure procedural safeguards for pro se parents and alienated families. A lot of pro ses don't know what their role is as far as GALs go. So there needs to be a little bit more defined for best interest. For pro ses. They need to define the best interest of the child using evidence-based standards instead of it just kind of being a wild card. They need to prohibit GAL role conflicts and mandate annual trauma-informed training. That will solve a lot of the issues, not just for your state, but every state.
Thank you. Mark, a follow-up question with this. Did you see, when you were doing your audit, anyone that was, for example, in the back of the standards practice that they developed here in Pennsylvania in 2012, they made a very specific, almost timesheet, where it was very laid out about what they were supposed to do. It was almost a check boxes for GALs about. Did you see anyone submit any kind of hourly breakdown of that?
No, I didn't. Now, I will say, or at least I didn't see any standard. I did see that some outside gals submitted, and this would be more on the somebody that went into foster care or something like that rather than family court, because I don't see those. But you can see that some lawyers, or gals that are lawyers, they take it very professionally and take it very seriously, and they would lay it out, and I was very pleased with that. But I would say the majority did not. It would be like one invoice line item. Now, that's not to say that they're not giving it to judges. The judges did not participate in my audit, and so I don't know. I also want to mention really quick too, there was an outside group called CASA, and I forget what it stands for. Somebody here I'm sure knows. They actually were very professional. They had far more training, at least here, in the Lehigh County area, I imagine all throughout Pennsylvania, and they did a really good job. And their processes were really good.
Okay, great. Thank you. And another question for you, Mark. Does your audit for the gals have anything to do with the misdiagnosis abuse against Lehigh Valley Health Network?
It is a lot of the parents that I dealt with for the cost of misdiagnosis did complain to me. And then after they complained, I got other complaints, from family court as well. The parents talk to each other. And so, yes, it definitely started there. It wasn't specifically because of that, but it was the beginning of all the parents that I got complaints from. And then once I got more complaints, we decided to do this investigation.
Thank you. And I see another question about gals, their side. So thank you, David, for your work or for your question. Did you find that gals were willing to participate and if they were able to give their opinions on how they feel like the state is going in Pennsylvania, how they're provided with resources?
I'm sorry.
Did you get any gal perspectives in Pennsylvania?
Oh, we did. Yeah.
And what was their general?
Yeah, go ahead.
I was going to say, what was their sort of perspective on the situation?
I mean, they were one of the ones that really introduced the money aspect, meaning, that they were not getting enough money. I mean, it wasn't a complaint specifically, it was a reason. So it wasn't like they were whining, right? Like they know what job they're taking. And typically what it was the ones that were willing to travel for the children that were complaining about the ones that weren't willing to travel for the children. So a lot of the responses that we got from the GALs were actually lawyers that, they were earning $500 an hour and they were happy to take the 100 and they would do whatever it took. And then they were upset with the lawyers that didn't do that, that said, hey, look, like they basically their feeling was, if you're not willing to do the work, just don't be a GAL. Just don't take it. And even though I think all of these lawyers really are, the ones that we talk to anyway, really were trying to figure out what the best interest of the child was. They had different methods of doing that, and not all of them liked our process or procedures either. Like they think that there's positive change that could be made.
Thank you. And further, David was talking more about getting the perspective, and I know that Jeff gave some feedback about thanking you for your comment, and I do want to say that we are not here to say that gals aren't doing a good job and they're trying to do this wrong. What we're saying here in Pennsylvania is that just generally there's no rules. It doesn't feel like that people understand not one set of rules, and that would make it easier for everyone. And in terms of also what you can do when you're a litigant, there was just recent litigation that said that gals don't have immunity. So it does set them up to be sued for a malpractice. So it's more reason to have some kind of rules and safeguards when it comes to gals here.
Absolutely.
Let's see. So what do you think, Mark, if you could just summarize, what do you think would be the best solution at this point?
Well, I think, I mean, I like some of what Robert has done, quite honestly. Like some of the solutions that he is, and I don't know all of the solutions, so I shouldn't even see some, but the ones that I have read, I think could be very helpful, here in Pennsylvania, as well as other areas. For Lehigh County in particular, what I would like to see is greater transparency, so that would include, making sure that parents had access to who that JAL was seeing, what they were doing. It's also really, I really believe it's important that the parents know right away what what a gal's role is, because most of them really tend to believe that it's a lawyer. So it's almost like, I don't want to call it Miranda rights. I don't know what the right word would be, but like this is what's happening. This is what a GAL does. This is what your expectation could be, so that people know right up front. But I really think that Robert should take this question, because I think that there's some really good positives there.
Thank you. Yeah, so the guardian ad litem in some states, I guess Pennsylvania, you have to be an attorney, but a lot of states you don't. That's an amicus attorney. The guardian ad litem can just be appointed by the court. They just take some classes, a couple hours, and you're good to go. And that's the scary part, because they don't know what the law is, they don't know any of this stuff, and here they are acting in best interest of the child. They overstep their boundaries. There is no uniform thing going on. In Texas, a lot of them are getting in trouble because if they try to, and this is probably for a lot of other states, I haven't researched it yet, but I know in Texas, a guardian ad litem cannot give a recommendation on custody. They can't say how much time they think the child should go with the one parent or the other. That is a home study issue, and there's actually laws against the guardian ad litem overstepping that boundary. So there's a lot of things that, and the funny part is my attorney didn't even know this. I had to find it for them and look it up. And so this is kind of where my whole thing with looking into the law and finding what the loopholes are, if you just read the law, you'll find a lot of stuff that you didn't know, and things that, because a lot of things that people are doing is, they see someone doing it, so then they go do it. And if they got away with it, then they do it too. So, but yeah, so that's where a lot of the laws that I'm coming up with, to close down these legal loopholes. One of the biggest ones is actually having the judges do not recommendations, writing their findings of facts and conclusions of law. Because right now, you don't know why a judge did what they did. Having them do that alone, now you have something in concrete that you can go and actually take. If they didn't do it right, or there wasn't anything in your case for that, you can take it to an appellate court and actually argue it. But how can you argue something you don't know? You're just guessing at that point. But having the judges have more accountability and write their decisions of finding facts and conclusions of law, not the other attorneys, the judge themselves. They need to quit giving that, to other attorneys to write for them. But closing these legal loopholes will solve a lot of these issues.
Thank you. Can anybody on the panel speak to the training that a GAL receives in Pennsylvania, the required training to be a GAL, and any continuing education?
Just by code, the dependency attorneys, they created, as the informational video had relayed, a training video and some associated materials that go along with that they are supposed to do. They don't have to. By law, they don't have to take it. It just helps counties to be able to qualify for reimbursement. And again, on the custody side, there's no requirements whatsoever. You just need to be a lawyer. So, yeah.
Yeah, or mental health professional on the custody side.
Thank you, Rayo. Yes.
Yeah.
Or mental health professional. Yeah, and I think there's a good and bad in terms of guardian ad litems being attorneys or not attorneys. There's good and bad either way. So I don't know that there's a silver bullet. I think that additional training qualifications should be included or mandated either way. So they know what they're doing when they're getting into it, how to work with youth and those types of things.
And I think our last question is the resources. If you just, Jeff, you want to tell them about the resources and then wrap it up. Thanks.
Okay, thank you very much, Rayo. There was a link put into the chat to the Dad's Resource Center that has all the reports that we're spoken about today. And once we have the video, we'll post it on that page too. We're going to get it out to everyone who attended. We're going to get it out to everyone who showed any interest. We're going to get it out to a lot of folks. I want to thank Mark. I want to thank Robert, Holly, Rael, Caleb. What we tried to do here, folks, is civic engagement, right? We're not trying to tell you what to do. We're not trying to tell you you're all wrong or you're all bad. We just wanted to put all this information out to start the conversation. We really believe something needs to be done, but we want the folks who are doing the work to help be a part of that process. That's why we're doing it this way. And so I really want to thank, more than anything else, all the folks associated with the counties, all the people who are the practicing guardian ad litems or service providers, some of the people from the state legislature who are here today. We want to thank you, because together, if we're just reasonable and work with this in a reasonable manner, we can do better on behalf of the children to make sure they're getting their needs met. They're getting the services that they need from guardian ad litems, and that everyone feels a lot better about this process. So with all that being said, very appreciate everyone taking their time during lunch here on a Monday, and have a good week. Thank you very much.